and welcome to this real-time update from HRM Services. As always, I'm Jody Schaefer, and I'm here to bring you some breaking news. We have just heard from the appeals court here in Michigan. As you may recall, we've been watching and waiting anxiously for their opinion on whether or not the legislature acted in a constitutional manner when it adopted ballot initiatives regarding minimum wage and paid sick leave back in 2018, and then amended both of those initiatives in the same legislative session. And there's been some back and forth through the courts about whether they could do what they did, and the impact of those court decisions had many employers just waiting on the edge of our seats here. And really, we were looking at this deadline of February 19th, which is when the stay was going to be removed from our circuit court ruling. And the circuit court, if you may recall, said that the Constitution did not allow the legislature to behave as they did, meaning that the current laws on the books for both minimum wage and paid sick leave would have to be reverted back to the 2018 ballot language. And those were going to be some huge, significant changes for employers in many industries. And so that decision was appealed, and we've been waiting and waiting to hear what the appeals court has decided. And the verdict is in. It just came in less than an hour ago. So the three judge panel for Court of Appeals ruled unanimously that the legislature did have the constitutional authority to do what it did. And therefore, the laws that are on the books right now for minimum wage, for the tip credit, and for paid sick leave will remain unchanged. So let me say that again, folks. For now, we do not have to do anything different than what we've been doing since 2018. Minimum wage, tip credit, and paid sick leave will remain unchanged for now. The reason I say for now is because this case will most likely be appealed to the Supreme Court. And I had mentioned that back in December when I was laying out the roadmap. And so I don't think that's going to change. Whether or not the Supreme Court decides to hear the case remains to be seen, but that is the next step. But between now and then, we can all just take a big sigh of relief that we don't have to make any drastic changes. So I have to tell you, I'm like excited about this. You know, my energy is up because I'm shocked. I thought for sure all of the, the folks I'd been talking to and so some of the murmurs I'd been hearing, I think many of us were just assuming that the Court of Appeals would sort of side with Circuit Court. And we were gearing up for some very significant changes to have to be made. In fact, I'm registered for a webinar next week to talk through how we're going to make these changes. But alas, what do we know? How can we predict the courts, right? We cannot. So in this case, Court of Appeals went against the Circuit Court ruling. And for now, we can all just take a breath. What the Supreme Court will decide to do and whether or not they even decide to hear the case remains to be seen. But one thing you can be sure of, we will be following this very, very closely. If there are any changes or any updates that need to be shared, we will be the ones to bring them to you. And as always, if you have any questions, you can reach me directly, Jody Schaefer at workwithhrm.com.